Hello, ladies and gentlemen. Welcome after the second coffee break. Hello also from my side. My name is Ivana Marković, and I'm originally from the Department of Criminal Law. So as many of you, I'm also a guest here actually at the conference. So I would like to thank the organizers for the invitation. Always a pleasure to work with you. We're moving forward with the conference, but we're also moving forward in time. To be more precise, we arrived in medieval times, and to our second session, a short yet sweet one, just right before the lunch break. It's titled "Punishments for Witchcraft," the name of the session, and I have to give one remark at first, namely the third panelist of today is fulfilling her curricular obligations today. So we will have today three speakers on two topics, to be more precise. So right now, without further ado, I'm giving the floor to our colleagues from the University of Belgrade Faculty of Law, to Đorđe Stepić and Marko Romić, and they will talk about punishment for the crimes of sorcery in medieval Serbian law. Also, another remark, as we have enough time, they also have the privilege, if they like, to speak a bit longer than the others, so you have up to 20 minutes. And afterwards, we will start the discussion. Thank you.
Thank you for that. Semper Fidelis to Iustoria, to this wonderful organized scientific conference. It seems like it became something constant in my academic life, and not just mine. And yet its diversity, a large variety of topics, and dear colleagues from all around the world continues to amaze and inspire me. Just give me a brief moment to express my great admiration for hard working of my colleagues, and for this, I would say, tremendous work that you've done here for these past 4 years. And that is to reassemble us on this annual conference of legal historians. Let me be allowed to thank Professor Nina Krštelnin for everything that she has done for all of us who are very fond of legal history. Few years ago, on this very session, there were two authors that had different opinion about same legal topic and same legal matter in Serbian medieval law. And that academic dispute lasted throughout the next two conferences. And yet today, these same authors are here, bound with the same topic at the same time. And one little difference is that we are not in Serbian, but in English session. So I'll begin with some introduction remarks. In legal monuments of previous age, we could say legal documents that were predecessors of Zakonopravilo and Dušan's Code, we face with various terms for criminal act as an illegal and social dangerous act. Old Serbian law sees illegality in its substantive manner and comprehend criminal act as an attack on individual or society as a community. Sometimes it has that special word, such as obida or zlo or krivina, and sometimes criminal act has a name of its consequence, such as krv or vražda. These terms in contemporary legal theory symbolizes not just substantive meaning of criminal act, but also consequence and the punishment itself. Under influence of Byzantine law, in medieval Serbia, we can see traces of one particular perception that criminal act has its own formal side. And that means that something could be marked as a criminal act only if church or state regulates that with law. We can see that already in contract of Stefan Nemanja and Dubrovnik from 1214, and in Žiča Charter in the part of criminal act against marriage and family. There is one well-known typology of criminal acts which distinguishes four main groups of criminal acts. So the first one, criminal acts against state, criminal acts against church and faith, criminal acts against property, and criminal acts against person. In this modest attempt to show how these acts against Orthodox Church and faith were treated in Serbian medieval law, we'll begin with the oldest authentic Serbian legal monument, Zakonopravilo of St. Sava, or Nomokanov of St. Sava. On this place, we won't speak about heresy or proselytism, which are some kinds of that same group of criminal acts, but we'll speak about crime of sorcery, and not to think about the witchcraft or wizardry. It can sound a little bit like Harry Potter. No, we'll speak about sorcery, and we'll explain why no witchcraft. So that's the period of time, 12th to 15th century, end of 12th and beginning of the 15th century. And we can move on another slide. I'll explain what does this mean here. As we can read in Zakonopravilo in chapter 55, title 39, provision 2, the one who is practicing magic and that can hurt the other people, he or she tries to produce magic, eventually like some potion or other magical thing. In order to sell those magical potions, they will be punished same as a murderer. On this place, we should stop a little bit and consult with manuscript of Byzantine Prohiron Nomos in same provision, where it is stated that one will be punished in the same way. We move back now to Ekloga a few centuries ago, 1.5 centuries ago, and provision in Titulus 27, provision 43, where we can find that this crime drags along that penalty. But if someone is practicing magic and he or she is seen by others, those are obliged to report him on public court. And there is penalty prescribed for eyewitnesses who don't report such sorcery or sorcerer. And it is stated in Nomocanon, their punishment shall be to suffer capital punishment. This same provision, that's the point 2, 39.12. This same provision we can find in Prohiron, but in other place. And till now, it's not clear why this numeration is not the same, having in mind that both Zakonopravilo and Prohiron have the same number of criminal provisions, I think 86 in total. The great battle is being waged between church and paganism in those years, so perhaps that's why divination by idolatrous sacrifice is banned, and if someone do it, punishment for that criminal act is decapitation with the sword. Divination, according to the Holy Fathers and to the church teaching, was only permitted on a holy liturgy in the moment when the holy sacraments becoming from bread and wine to holy body and holy blood of Christ. This relic of old pagan religion is so deeply incorporated in Serbian medieval society that it wasn't forgotten ages after Christianization of Serbs in 9th century. Sorcery was not only related to some unnatural powers or making poisonous potions, but also invocation of devil himself. If someone is doing that in ignorance, as it is stated in this provision 39.21, that is the only case in which someone could be spared of very severe punishment, and that is capital by the sword. It is interesting that medieval law knows two different categories of people who are connected with the devil. So one category, those who are possessed, so their declaration of will is limited, and we will not discuss in this paper, but it can be a really interesting topic for someone or some other conference. And the second category is those who actively deal with the devil, which is criminal act that we spoke here now. Here we can conclude this part of provisions that are directly connected to the criminal acts of sorcery, and we saw that everything that has a link with magic, unnatural appearance, or has something with the devil can be seen as an act of sorcery, which is followed with strict and usually deadly punishments. And those punishments are commonly equated with various punishments for murder. On the other side, we have this 3921 provision. That is one specific provision that has more connected to further part of this paper, and it will be presented by my distinguished colleague. And that is a case of poisoner. Whoever prepares a drink that results in disease and death will get death penalty by the sword, regardless if the poisoner or the one that is poisoned belongs to bondman or free. In conclusion to this part, I would just like to remind you that the reception of Byzantine law in our legal tradition was enormous, and one argument for that are these provisions from Zakonopravilo, these 5, if we can all see it, about crimes of sorcery. Compiler of Nomocanon was aware of circumstances in Serbian lands, and it's not a coincidence that these provisions are accepted in its original form, and that's really important to say, as they are prescribed in Prohiron and other legal acts, as we can see here, Ecloga Appendix, Ecloga ad Prohiron Mutata, Ecloga Aucta Privata, these are all. And what is next? I yield the floor to my dear colleague.
I'm sorry, I hope everyone can hear me. So we are just moving a couple of decades or slightly less than 1 century into the future. So this time we see that the Byzantine law has been a part of Serbian legal tradition for quite some time. But until that point in Serbian history, Serbian legal history, we didn't have our own code of laws. That is until 1349 and the codifying work of Emperor Dusan. Actually, this work results in what is known as the Emperor's Tripartite, which consists of the code of the pious Emperor Stefan Dusan itself, the abbreviated syntagma of Matthias Blastares, the monk from Thessaloniki, and again from the law of Emperor Justinian, which is a short compilation of mostly agrarian law, which is not going to be mentioned here. The 2 parts of this tripartite that we will see, however, are the provisions of the code and the abbreviated syntagma, which was used as kind of a judge's manual on how to apply Byzantine law in medieval Serbia. And both of them mention crime of sorcery. So for all those our foreign guests who don't know this, Dusan's codification, the Code of Emperor Dusan, is opened by Article 1, which isn't actually a norm but a general motivation. It states, and as of Christianity, this is the way Christianity is to be cleansed. And what precedes then are various provisions that detail church life and different institutes of church law. But the article that is most interesting is Article 20, which is titled On the Eresniks who burnt dead bodies. Eresnik again comes from the word eresnota, which means the truth. So these types of sorcerers are known as truth seekers. And the sorcery that they are using is the burning of dead bodies under the assumption that the dead are vampires or werewolves. And this is again mentioned in the Nomocanon of Saint Sava, in a general comment made by the compilator that many of these pagan rituals still persist. And again, he treats them with complete disregard. It says that it is some absolute folly to still believe in such things. But as we see, even a century and a half later, this provision still makes it into the Code of Emperor Dusan. And the provision actually states that in the village where this kind of ritual is performed, the collective liability of the village is to pay the vrajda, and the vrajda is the penalty that is paid for voluntary murder. So again, similar to Byzantine law, in a completely different legal tradition, and this is Serbian customary law, you have the similar treatment of this crime. Again, what tells us that it is no direct Romanian or Byzantine influence, but rather the codifying of Serbian customary law, is the sentence that is given. Vrajda is an instrument of Serbian customary law and not a Romanian influence. It is a monetary fine that is paid for, in most cases, voluntary murder. The second thing is, some historians have pointed this out, well, you have provisions in the Ekloga, in the Prohieronomos, that speak of those who desecrate graves. But the difference is that the guys who desecrate graves in the Prohieronomos are doing it for different purposes. One is to reuse the materials for house building, and the rules of St. Basil the Great actually states, well, that is not so much of a great crime, rather than just plundering graves for some monetary values or jewelry or something like that. What we see in Serbian law is not that. There is no mention of it aside from the abbreviated syntagma, but still it is a case of a pagan rite which is still live and kicking centuries after the Christianization of these parts has officially ended. The second article, which does relate to Romanian law and the reception of Romanian or Byzantine law, is Article 109, that states magicians and poisoners are to be punished according to the law of the Holy Fathers. Now, several legal historians in the past have deduced that the law of the Holy Fathers is actually referring to the Zakonopravilo or the Nomocanon of Saint Sava. So these are the provisions that Marko mentioned in the first part of his presentation. The reason Dušan's Code often repeats these norms, they're already a part of Serbian law, they're known in different compilations of church and state law, but the reason they are mentioned again is because they're usually dealing with acute problems, which means that the problem of the poisoner and the magician, the various types of sorcerers that we find, are still a huge problem even in the decades and centuries following. Now, these norms are usually found in the abbreviated syntagma under the title M1, and in one additional article that again explicitly states these sorcerers are to be treated the same way as voluntary murderers. And especially this is again underlined in the articles against the poisoners, because it is not mentioned, it isn't important to the lawgiver whether or not the person who is making the poisons is doing it for his own benefit or for the benefit of others. He is to be tried and convicted as a voluntary murderer. Again, attempted poisoning or bringing harm by sorcery is a reason for exclusion from inheritance from Title 12, and it states if one has been endangered by poison or sorcery, he is to be excluded from inheritance. It is the same way if it is in the case of the son or daughter or in the case of the parents. Again, the additional act that equates sorcery to murder is again mentioned here. So in conclusion, these two distinct periods give us a unique overview, despite of its differences. Sorcery is treated not as witchcraft per se, it is a term that is inadequate to describe the various forms of it. So you have the truth seekers, the cloud chasers, the fortune tellers, and various other magicians that use their sorcery in order to bring harm to someone. So it's not only something that is done against the faith, the common morality, it is also a crime against the person. When someone gives you the poison or poisons a person, it is as dangerous as if he makes an attempt at one's life in any other means. So Romanian secular and church law have influenced this, in that we see severe corporal punishments and even capital punishment with death by beheading with the sword. And again, Serbian customary law rears its head even later, because when these customs were in effect, there was no need for them to be codified. There was no need for them, when they are common knowledge, to be written down. Nomocanon is again a prime example of reception of Romanian or Roman Eastern Roman law. But then you see the punishment of Vrajda, which comes from the Serbian customary law. The difference between poisoners, sorcerers, magicians, and fortune tellers is made basically to distinguish the degree of danger they pose. So if someone is a poisoner, he's much more dangerous than someone who just tries to be a fortune teller, or someone that tries to gaze at the stars or something like that. And again, this is a prime example of a tendency that in Serbian legal history is known as fight against popular religion. This kind of in-between between the recently adapted Eastern Orthodox Christianity and the remnants of paganism that were there. Some of them are actually included in the new religion, such as given the attributes of old pagan Slavic gods to some Orthodox saints, but others, like these practices of poisoning and doing magic and idolatry, are strictly fought against. These practices against the church, these are practices against the state, and the general character of the state, of the Serbian medieval state as an orthodox country, is again jeopardized and is reacted against with these norms. I thank you for your attention, and I welcome the questions.
Thank you also from my side. If you have questions, I hope you have some. Keep them for the end of the discussion. And now I give the floor to our second speaker from Warsaw, Katarzyna Dudek. And the title of her presentation is Witchcraft and Law of the First Republic of Poland, 16th, 18th century, Causes and Effects, Occurrence, Trials, Penalties. Katarzyna, I hope you can hear us and we can hear you.
Yes, I can hear you. Can you hear me?
We cannot. Now we can see you.
And hear? Yeah, you hear me?
Yes, we do.
Yes, we can hear
Right.
you. We can see you now.
Do you maybe have a
Okay.
presentation?
Yes, I've sent you a presentation to the Iustoria email because I'm unable to share my
I
screen.
think you should be able now. We just made you the presenter.
Okay, great. Thank you
It's
very
just
much.
simpler if you scroll it.
Okay, so I'm gonna share my just a second.
And also, as I said before, Katarzyna, you have enough time, so don't
Okay.
feel in rush.
Okay, thank you very much. So maybe I will just change. Okay. I think this would this be all right if I will broadcast it that way?
Yes, perfect. Thank you.
Thank you very much. So good afternoon, everyone, and thank you very much for having me today. My topic concerns the witchcraft in law of the First Republic of Poland from 16th to 18th century, its causes, effects, occurrence, trials, and penalties. First of all, I would like to mention that Poland, inter alia, due to the Warsaw Confederation of the year 1573, is often called a country without stakes. Why is it so? It is so because the Polish National Assembly, Sejm Konwokacyjny in Warsaw, signed this document on January 28, 1573, and this document, Warsaw Confederation, was one of the first in Europe to grant religious freedoms. This was a significant milestone in the history of Poland and Lithuania, as it allowed for religious tolerance for nobility and free persons within the Polish-Lithuanian Commonwealth. This marked the official start of religious freedom in the Commonwealth, and while it didn't completely prevent religious conflicts, it made this region way more tolerant and secure place than most of Europe at that time, particularly having into consideration 30 Years' War. In other European countries, especially in the West, pogroms of witches, witch trials, widespread panic, and witch hunts were a mass phenomenon. In Poland, such events had much less resonance. However, one should consider whether or not such situations did or not happen in practice at all. And of course, we cannot say that it didn't happen in Poland or Polish-Lithuanian Commonwealth at all. And so witchcraft was also a problem of Polish legal system at that time, and also pan-European or even global phenomenon, taking into consideration the trials in Salem. But as for Polish history and history of witch trials in Poland, witchcraft history is a subject of considerable complexity, particularly in Poland, because legal historians are confronted with a lack of established paradigms and terminologies that would enable a thorough understanding of this phenomenon. For instance, in English-speaking countries where it's more popular to research on this topic, in English, there's a paradigm formulated by E. Evans Pritchard, and it assumes inter alia that there are different words to describe magical activities. Witchcraft as an ability to create, sometimes subconsciously, a desired result, and people who had this ability had so-called witch substance, so kind of a talent to create a desired reality. And in English also there is sorcery, the state of learning about spells and hexes from evil powers. Sorcery was undoubtedly worse in those standards. And there are not any similar linguistic distinctions in Polish. Some legal historians, however, they try to adjust Polish language to distinguish those situations. Yet it is not as universal as in English. So there still would be differences between different legal historians. I will change the slide now. Yeah, and there are ideas like in Polish, if it's wiedźma or czarownica as in English, between witch and sorcerer, but it's not as it's not a fixed paradigm that every researcher would stick on. And another linguistic remark should be raised here. Mrs. Małgorzata Pilaszek, a Polish historian and a researcher, uses in her publication the general term witch trials rather than witch hunts, because the former objectifies the whole phenomenon, its trial, and doesn't suggest, as the latter, the witch hunt, that it was state-operated massive oppression of a group of people. And in the opinion of most contemporary people, until the humanitarian perspective in criminal law has been somehow obtained, and this rule of humanitarianism, this form of trial was in fact a normal means of dealing with conflict. So historians shouldn't, at least in this researcher's opinion, shouldn't be using the term hunt. It's better to say witch trial. And for the sake of this presentation, before we go deeper, I'd like to clarify that I will be using Poland to refer to both the Polish-Lithuanian Commonwealth and the First Polish Republic for simplicity's sake throughout this presentation. So as I mentioned before, the First Republic of Poland, also known as the Polish-Lithuanian Commonwealth, was a state that included multiple nations such as Poles, Lithuanians, Ruthenians, and various other cultures and religious affiliations. And in Poland, the first mentions of witch trials appeared in the 15th century, which is relatively late compared to Western Europe. So it was a completely different reality while it began, both religious and social. The intensity of witchcraft trials in the Polish-Lithuanian Commonwealth was one of the least intense in the entire old continent. The specificity of the Polish state was that despite the officially issued restrictive laws directed against enemies of the church and religion, because witches were seen as ones, those laws were not overly respected. What influenced the dynamics of the phenomenon of witchcraft trials was the dense parish network and the fight against Hussite heresy, especially since witchcraft was initially treated in Poland only as a heresy. At first, at the end of the Middle Ages, it was only a crime of insulting the personal goods of a person, so-called and public offense under secular law, and only later it became, precisely in the modern era, it was recognized as a crime, public crime, so a crime that most strongly undermined the divine majesty. And such crimes had the characteristic that the authorities had to decide that whoever behaved in this way acted in a way that can put God's wrath on whole community, because witches were described as offenders of the Creator, and they could brought down God's wrath on everyone. Another characteristic of the Polish-Lithuanian Commonwealth was that the minimal interest of the Church itself in judging witchcraft trials. Even in the late Middle Ages, only 0.5% mentions and records concerned witchcraft trials. But interestingly, even at the end of 18th century, after witchcraft punishment was abolished in 1776 under the influence of Enlightenment currents, one could still be punished for infamy. And this is the situation when someone accuses another person of magical practices. So if I were accused, I could sue the person who accuses me for witchcraft, even if I couldn't be punished at the end of 18th century. But still, I think people saw it as such an offense of personal goods that we could sue somebody who says that we are doing some magical practices. But it was only in 18th century, so at the very end of witch trials. And now I would like to tell you why is 16th, 18th century a time range of my presentation. And actually, this subject also raises more questions than answers, and historians and legal historians alike grapple with the overreaching question of how to properly define the borders of the time period under discussion. Regarding the borders of this phenomenon during this time, we'll follow Professor Michael Ostling from the University of Toronto and set them from 1543 to 1776. Although municipal law provided the death penalty for witchcraft since the 12th century, the era of witch trials in Poland began with the constitution of the year 1543. And this constitution transferred jurisdiction over witch trials from church courts to state courts. And it's worth noting here that in Old Polish constitution, the word constitution isn't a constitution in today's world meaning, but constitution was just a bill of the Polish parliament of Sejm, rather than a construction of constitution in the modern sense of the word. This constitution of year 1543 aimed to prevent church courts from having too much power and explicitly stated that questions of witchcraft and magical practices were not matters for the state. However, state courts were granted the authority to rule on those cases in which the accused caused property damage to someone or caused illness or death by their magical practice. So it was a means of protection upon the state court, of protection health goods that were endangered by somebody's witchcraft practices. Despite the attempt to limit trials after this constitution, they continued to occur because it was believed that while state is gonna act on it, the number of trials will be fewer because it was taken from the church jurisdiction. In 1544, just a year after the signing of the constitution, Dorota Gnieczkowa was burned at stake in Poznań in one of the earliest known state trials of magical practice in Poland. So I want to put the stress on it that it was one of the earliest known state trial, not a church trial. Why the constitution aimed to prevent such trials? It inadvertently provided a means for seeking responsibility for, as I mentioned, property damage, and this gate to go on trial as a means of protection against property damage or health damage. This gate was widely used. And the year 1543, the year of this constitution, is also regarded as the beginning of witch trials by Polish historians such as Zbigniew Zdrójkowski or Janusz Tazbir. Interestingly, in the mid-16th century, when the constitution was passed, writers from the Catholic Church protested against the secular courts deciding witchcraft trials, citing linguistic inconsistencies and the lack of the use of Latin term maleficia in this constitution, in this bill, to describe witchcraft. The debate over the recognition of the year 1534 as the boundary date, the beginning of witchcraft trials in Poland, is also caused by the fact that while secular courts provided justifications for their judgment in civil cases, judges did not invoke this bill, this constitution of 1543, but instead they just justified their actions directly from the Bible. It's Exodus 22:18, "Thou shalt not suffer a witch to live." For 2 centuries, many representatives of the church, such as the Bishop of Włocławek, Czartoryski, and Father Gamalski, as well as many bishops in pastoral letters to dioceses throughout the crown, advocated handing over these matters to theologians, only to theologians, not state judges. And it was only in the 18th century that King August II forbade lower courts in some districts from conducting trials for witchcraft before they were conducted in ecclesiastical church courts. Now, having set a time limit, let's take a look at the main lines of judicial law during the first Commonwealth. With regard to urban law during this period, it's worth noting that the origins of witch hunts in Poland can be traced back to their introduction from Germany, where these practices had already gained significant momentum. However, it's important to note that despite the occurrence of witch trials in Poland, these were significantly less frequent and less severe than those that ravaged Western Europe. The role of Catholic Church in influencing the trajectory of witch hunts cannot be understated. But it's interesting that in regions where the Catholic Church held a dominant position, such as Spain and Poland, witch hunts were relatively uncommon, as clergymen were less preoccupied with the eradication of perceived opponents, such as witches. Conversely, in countries with strong Catholic Protestant tensions and conflicts, such as Germany, the situation was markedly different, with the Church playing a significant role in promoting the demonization and persecution of witches. Another interesting dimension to the study of witchcraft history in Eastern Europe is the role of Orthodoxy, which was mentioned before, but I found other information, but more concerning Russia. Unlike the Catholic Church and Protestant denominations, demonology was not as well developed in Orthodoxy, which translated to the lack of witch trials in Russia. To the extent that such trials did take place, they tended to target men, unlike in Europe, where women were predominantly the victims of such persecution. The nature of witchcraft trials in Poland has evolved over time, with the medieval era seeing it being classified as an offense against personal property, which required a formal complaint to trigger a legal proceeding. However, during the early modern period, such as 17th century, the practice of witchcraft was viewed more as a crime against God, which was a more serious offense, of course. It's important to note, however, that the paucity and often incomplete nature of the available statistics on witchcraft trials in Poland make it challenging to draw definitive conclusions on this topic. Nonetheless, the available evidence suggests that the experience of witchcraft history in Poland differed significantly from that of Western Europe, with a relatively lower incidence of trials and persecution. Also, many publications, they tend to color this phenomena in Poland in order to just put more discussion, to provoke discussion, to interest public. But in fact, basing on those available evidence, this was relatively lower number of witch trials in Poland rather than in Western Europe. But going back to Poland, land and urban law were not codified, but their popularity grew in legal literature. Therefore, it is difficult to find, because it wasn't codified, it's difficult to find a legal definition of witches, magic, or witchcraft in today's sense of the word. Partial reception of Constitutio Criminalis Carolina, the first modern German criminal law of the 16th century, was expressed in the primacy of the deterrent principle or general prevention in criminal law, and the partial introduction of the inquisitorial process into the procedure, along with appropriate evidence such as torture. The elements of this process were precisely taken over by the land process in most important criminal cases. It's worth emphasizing that in witch trials, torture was meant to lead to obtaining the crown evidence, and the victim was tortured in such a way as to cause them not only to admit guilt, and admitting one's guilt was a crown evidence at that time, but also admitting help them to save their soul. Returning to the witchcraft trial, it's worth pointing out that this one is one of so-called special trials. The greatest intensity of witch trials took place in the northwestern territories of Commonwealth due to the influence of Germany. It was in Germany that witch trials intensified during the struggles between the Reformation and the Catholics. Thanks to development of printing in Poland, Western literature describing the signs by which witches could be recognized and the methods by which they could be forced to confess to guilt also became popular. The most famous book of this kind was the popular Malleus Maleficarum, written by Heinrich Kramer in collaboration with another inquisitor, Jakob Sprenger, and published in 1614. Some Polish scholars in later centuries criticized the translation of Malleus Maleficarum to Polish. Proceedings in which trial could be initiated by a private accusation or as a result of being called upon by a person who had already been accused of witchcraft and summoned to torture to reveal those whom they knew as witches as well. If the court accepted the accusation, the accused were arrested and subjected to drowning or torture. Drowning involved tying the suspect's left hand to their right foot and their right hand to their left foot, and tying a rope around their waist before releasing them into the water. The ability for a woman to stay afloat, which was not uncommon with women's clothing at the time, was considered to be a sign of cooperation with unclean forces. This was a kind of revival of the cold water ordeal known from the medieval ordeals. Prisons for those accused of witchcraft were arranged to isolate them from the ground, because it was believed that from the ground they drew their power. For this purpose, they were placed in barrels, so-called witch's barrel, or logs. Since it was believed that those powers could have its seat in hair, the accused were shaved. Torture was not limited to 3 times for those accused of witchcraft, but was applied until the accused confessed. And it was only in 18th century when King August II forbade lower courts in some districts from conducting trials for witchcraft before they were conducted in ecclesiastical courts. However, even at that time, the number of witchcraft trials in Poland gradually decreased, which should be attributed to slowly awakening of enlightenment in Poland, rather than to this royal decrees gradually transferring jurisdiction to ecclesiastical courts back again. The parliamentary decree of 1776 formally abolished the death penalty for witchcraft and effectively ended the period of witch trials in Poland, at least on this scale. Most of the later trials took place after partitions, when the laws of the partitioning powers were applied. In the territory of present-day Poland, determining the final date of the witch trial era, is difficult due to the fact that in 1772, the first, so 4 years before the death penalty was formally abolished, 4 years before that, the first partition of Poland occurred, and some of the territories that belonged to Polish-Lithuanian Commonwealth then and now were already beyond its borders. Therefore, when considering only Polish law, some of these territories must be excluded from historian studies earlier than 1776 or later, because they belonged to Polish-Lithuanian Commonwealth, and then they were already beyond its borders. Therefore, when considering only Polish law, some of these territories must be excluded from historian studies earlier due to the fact that they were subject to a different legal order before. And that would be the end of my presentation. Thank you very much for your time.
Katarzyna, thank you very much also from my side. And now I open the floor for discussion if you have questions or remarks, either from the public or from the public online. Please put on the mic.
Do we have evidence for witchcraft and poisons in Serbian law? Such as like books or something like written, not just in the Dušanov zakonik and zakonopravila.
So thank you for the question. We don't actually have any sources about legal practice on the matter, because the logic was that again, this is a common disease, you know, that Serbian medieval law suffers. We have very little sources from legal practice as a whole, and it is quite reasonable why we don't have many sources from the time, because in the time of customary law, probably the judgments wouldn't even have been written, and until the time of Dušan's Code, the judgments didn't have to be written. So we don't have any kind of mention, but we can deduce the intensity of the issues based on the fact that they needed to be addressed again and again. And some of them harkening back to customary law, and some of them repeating the Romanian law, or rather Byzantine law, that has been integrated in the centuries before. So that's the short answer. Basically, we don't have the sources, but the intensity at which these things, the poisoners, the magicians, etc., reoccur in the legal sources, do give us a pretty clear picture of how big or small a problem they were.
And that fact that we don't have any practice made our job much easier.
Do you have further questions? Professor Simon.
It's me. Yeah, I want to ask concerning this vrashta. This is not a corporal punishment. This is a payment. Yeah, and I would like to know: do you know something about the relation of corporal punishment and this vrashta? I think it's a kind of compensation between the damaged part and the perpetrator. Can you say something about the relation of these two kind of sanctions in the medieval Serbia? I mean, do you think that this punishment of witchcraft, of sorcery, is an exception, and other kinds of criminality were sanctioned in this way of vrashta? Or do you think that other kinds of criminality also had been sanctioned by corporal punishment or even by capital punishment. How was the relation of these two very different kinds of sanctioning offenses? Yeah.
Thank you, Professor Simon, for the question. In medieval law, there are very few words that can mean so much as vražda in medieval Serbian law. And I once joke when talking to my students that you can see the entire development of Serbian medieval law just through the different meanings of this one word, and it's vražda. So vražda comes from the word vrag, the enemy. So the state of enmity that happens between the different collectives of the victim and the perpetrator of the criminal act. Through the centuries, the meaning changes, and it also encompasses the even before the monetary fine as some kind of compensation between the collective associated, the house or the family associated to the perpetrator of the crime, and that one of the victim. By the time we get to the late Middle Ages, in the period that we are covering in the Zakonopravilo and the Dušan's Code, it is already a penalty. It is a monetary fine that is even present in Latin sources. So from some charters with Dubrovnik, it is referred as pena vrzdae, and vrzdae is basically the same as vražda. So vražda is usually used as the name for the fine or the monetary payment to the state for the most serious offenses. So for murder or for some great injury that is also known as krv or blood, basically any kind of such corporal injury, and was used until Dušan's Code. So Serbian law is very, very iffy on the question of capital punishment. The first instances of capital punishment come into Serbian law, and indeed these grievous corporal punishments through Romanian law. And these influences are mostly from Arabic and Persian law and come from the sources like the Vasiliki, the Ekloga, and the Prohieronomos. And they kind of merge in this kind of mixed Serbo-Romanian system. With the Dušan's Empire, which was he styled himself as the Emperor of Serbs and Romanians. In some instances, the pena vrzdae, or the punishment of vražda, is still maintained and mostly pertaining to the crimes that have already been established by customary law. So, for instance, this kind of paganistic practices, or in some cases of even the involuntary murder, you have even the gradation between the common vražda, the little vražda, which was about 300 perpers, the common one was 500, and the big vražda was 1,000. So it exists as a separate entity in this mixed system. On the other hand, capital punishment is still used for some more grievous offenses. For instance, in the murder of a priest, in the destruction of a church on military campaign, and several different examples which are still equated to something like murder and have the same reasoning. The reasoning behind punishing these type of crimes against the faith, and in the example of sorcery that came to us from Romanian law, the logic is you are sinning against the church, against your fellow man, and against the state, and it needs to be sanctioned brutally. The logic with vražda in the case of paganism as a remnant of this kind of popular religion is in the case of digging up dead bodies under the guise of, pretending they're vampires or werewolves. By burning them, you're essentially, as it is poetically said, giving them back to death once more. So that's the reason why it is equated with the payment that was to be given to the family of the victim of the murder. So in conclusion, they both exist at the same time. It can get a little confusing, but in most of these more ancient Serbian customary influences, we keep the vražda, and in some other cases, we adopt the corporal and capital punishment system from the Byzantine law.
But anyway, we could conclude that that all these acts which were sanctioned by, at the beginning at least, in the Middle Ages, which were sanctioned by corporal punishment or capital punishment, most of these acts had a relation to the religious sphere. Outside of this sphere, if I understood you correctly, the payment, different kinds of rashta were dominant. Is this a correct conclusion?
Yes, that is the correct conclusion, because when accepting Eastern Orthodoxy, it came from the religious centers in the East, and the greatest wave of Christianization happened by the disciples from the first generation of the disciples of Saint Cyril and Methodius. And many of these crimes against the church were punished so severely under the influence of Romanian law, something that remained mostly against those old kind of pagan practices that were much more like, I would say, Serbian in nature, or more prone to Serbian customary law, still retain the punishment that remained from the customary law.
So, if I understood you correctly, you said that people affected by poisons or potions were excluded from basically their, I cannot remember the word in English right now, but nasledstvo? So, if inheritance, yes. So, if that is correct, why is that? Why were they excluded from their inheritance if they were affected by potions?
You didn't understand me properly. I said that was one of the reasons to exclude the poisoner. So if you are, let's say, a child and you want to haste things up because you have particularly rich or unbearable parents, so you can decide to try and use some magic or use a poison, but it is mentioned as the third reason out of, I think, 12 or 15 why you can be excluded from inheritance in the abbreviated syntagma of Matthias Blasares. And the reason is that it tells us, the positioning of the norm tells us how serious it was understood. Above it are only instances of like attempted murder, for instance. So it is almost equated to the same sense, as I've spoken before, to the very act of trying to murder someone outright, or trying to do that by the use of magic or poisons that have been given to you by someone.
Just one nota bene. One interesting part in Zakonopravilo, you have that in, I'm not sure what chapter, but I can see that. You can also be excluded from inheritance if you are possessed. And that's connected with this provision 39:21 of the people who are in connection with the devil.
Yes, you can. Yes.
So they excluded people who were possessed from inheriting because they believed in possessions?
No,
And
they
did
are
try-
possessed.
and did they try to like get the devil out and then inherit, or no?
That's your point of view. Or?
Thank you.
We have to talk about exorcism on a follow-up conference. Nina has also a question. Please, Nina.
Thank you very much. Just let me put me on the camera. So I have a few questions and comments for both papers. I'm just not catching myself, sorry. The problem of doing two things at the same time. Just a brief follow-up on what Professor Zeman was asking regarding the type of punishment for various crimes. It's not always just for religion-related crimes. I think I'd say that capital punishment or harsh corporal punishments are prescribed for the most serious crimes. So in Dushan's code, we have the severing of both arms for voluntary murder, for premeditated murder, or of both arms and the nose for rape. We have the severing of the arm and the tongue for the court official who participates in forging a judicial verdict and things like that. So it's very serious crimes of various kinds, but Dusan does not transfer wholly to that Romanian mode of corporal and capital punishments. He keeps the pecuniary punishments for the crimes of lower intensity, and even there are some, why I say pecuniary, there are still some fines that are paid in cattle and not in money, or at least prescribed, so we presume they are very old from customary law. Now, regarding our wonderful speakers, one general question for all of you, and then a few for each paper. The general question, since we've heard here that overall Eastern European systems had much less issues with witchcraft and demonology than the Western ones. We've heard about Serbia and Poland and Russia. Do you have any assumptions of your own as to why that was the case? Now, regarding the first paper for Marko and Đorđe, I'd like to suggest a nuance between pagan beliefs and popular beliefs. I know they're all sometimes referred to as pagan, but here we're not talking about people who don't worship God and Jesus and the Virgin Mary, but worship, I don't know, Veles and Perun instead. We're talking about people who do think of themselves as Christians, but who still have some superstitions, such as vampirizing to suck the blood of the living, and then of course you have to put a stake through their heart or burn the corpse to prevent the damage. So in that sense, when you said in the abstract you wrote, for example, that the digging up of the vampire must have been led by some proficient in the dark arts. They wouldn't have seen it as the dark arts. The reason why it must have been frequently led by a priest was because they thought, well, a holy man was needed to expel the dark from the vampire. So my question here is, what do you think, for example, that prohibition against digging up vampires, was it because they understood some things were superstitious and there were no such things as vampires and so on, or not, or perhaps they had some other reason, because we see that they treat some other things that we would now consider supernatural as extant, as in your example of possessed people. Similarly with poisoners and potioners, to call them that way, it's just various things you make to affect other people in some harmful way. We would think that today that some of them are physically explainable and some of them are mere superstition, but they did not know that at the time. And the suggestion to complicate your finalizing of the paper, but since Marko said it was so simple because there were no sources from practice, have you considered digging a little in the lives of saints from the period? Because there are some stories there of the saints fighting against dark arts, etc., that could be used at least as parallel examples. Now, Katarzyna, for you, first you've spoken about German influences on Polish law in this respect. I'm just curious, are there any counter influences or at least attempts of influences from other laws, for example, the Russian law you mentioned, or any other that you might notice? And more of a comment than a question regarding the water ordeal, since you said it was returning from the Middle Ages. Just as a comment, it's interesting that it's much older than that we find it in the law codes of ancient Mesopotamia. So it would be interesting to trace it all the way. Of course, that can be the subject of a completely different paper, but it can be a footnote in this one. And it's also interesting that in different cultures, whether the accused sinks or floats is interpreted in different ways. Somewhere you are innocent if you float because, well, you haven't been killed by the divine force, and somewhere on the other way around, if the water doesn't take you in, it means you are impure or you have some sorcery to keep you afloat, etc. I've overdone it. Excuse me.
Thank you very much for your remarks. I'm just gonna quickly address it. Thank you for this. And as for water ordeals, yeah, that's true. But probably I didn't mention Mesopotamia, for example, because I used a book only about history of Polish law, and I sometimes I skipped the fact that Polish law. So I didn't mention Mesopotamia, but in general, the medieval Middle Ages Europe. But thank you very much for your suggestion. Thank you.
Katarzyna, any guesses about the different influences on Eastern and Western Europe regarding witches? The first part of the question.
Yeah, so mainly I just mentioned Germany because there is the majority, or like 99% of sources are talking about German roots, and most famous trials were held in towns that were close to border, or were somehow influenced by Germany, but also there's a problem with researching Eastern lands of Commonwealth, Polish-Lithuanian Commonwealth, because one, we don't have many sources. Two, even if we have them, those are places abroad from Poland, so we don't have. It's not as deeply examined as those, from example, from Gdańsk or Poznań or Wrocław, which are now Polish towns, but were more closer to Germany, depending on time, of course. But yeah, in overall, I think that German influence is the biggest, and even from the perspective that in Russia and in that culture, they didn't necessarily persecuted women but men. But in Poland, the only information I found is about women trials. I'd say that it was mainly German Western influence rather than Eastern one.
Thank you.
Thank you.
If you wish. Okay, so the general question of the difference between the East and the West, as Katarzyna spoke so well, the greatest extent of witch trials and persecution usually came with the trials for heresy, and then later after the Reformation, when they are trying to preserve the purity of the Catholic faith. So I think it's the general atmosphere of the faith being endangered from the heretics, the witches, and various different fronts. So they decide to fight them as a common enemy. And she also mentioned the similar treatment between heresy and the trials of witches. In these, we don't have that. Quite the contrary, the Orthodox faith is relatively stable, except from those little dangers from popular beliefs and remnants of paganism. But also the situation in Southeastern Europe is relatively not so much interested after the Ottoman occupation of the parts. So even if we would have something similar in the 16th or 17th century, we just didn't quite make it through to that as a state collective. And the question about, and first the distinction between the popular and pagan beliefs, we didn't preface this enough, but we made a difference. The importance of pagan-like remnants in popular beliefs I think comes from that one little glossa from the Nomocanon of Saint Sava, where the compiler states, well, these are the different ways that people think that werewolves, the Vukodlaci, have appeared, and this is, and he uses some strong language, but it is, you know, rubbish. So you shouldn't believe everything that you see. And then again, a century and a half later, you still see the need of the Emperor Dusan to prescribe, well, just please people stop doing this. I mean, we are over this, I think. And the reason why they fought against the werewolves and vampires, again, can be traced through some additional sources. You mentioned the lives of saints, and we will certainly complicate the paper with that. But also to further complicate from my own side, the different ethnological sources like folk tales and for example, do speak of these types of dangers to the common folk. And the reason that the priest is mentioned also in this Article 20, if the ritual is led by the priest, he would be stripped of his priesthood, which again, I don't think is necessarily an influence of Romanian law, but something quite logical. If you're subscribing to this kind of popular belief and something that is so anti-Christian, then why are you the member of the organization? So that's the short answer, and thank you for the question.
Maybe just to add something about that devil thing. We see in hagiography from the 4th century, from the first systematically hagiography, that is the holy life of Saint Antonius the Great, that was written by Saint Alexander of Alexandria. We see that moment fighting with the devil, with the demon, and that became a commonplace in hagiography. And the first, we could say, hagiography in Serbian medieval period was the life of Saint Simeon, that was written by Saint Sava, his son. And from that first one to the end of Serbian medieval age, 15th century, we see in every systematically done hagiography that part where saint is fighting with the devil and the demon. But maybe it will be interesting for further researchers to see some parts maybe of sorcery that we've spoken about, or maybe that special status of poisoner in our hagiography, because I think that can be something that is worth trying, but devil will find for sure in hagiography. Thank you.
Thank you for the answers, and now I will misuse my position as a chair to pose a question to Katarzyna, and afterwards one last question from the audience, because we're already over time, but the topic is too interesting, I have to admit. Katarzyna, in the end, explained something that I wanted to ask before that. You said that the lower resonance regarding witch hunts and witch trials in Poland, you explained that despite of the influence of the Catholic Church, you explained that by the absence of actual fractions between different religious groups or religious denominations. So my question would now be, as a follow-up, what happened between the 16th century and the Warsaw Confederation with all the freedoms, religious freedoms that were granted, and the 18th century, when we talk about now about tortures as a method to obtain evidence? So what happened in the meantime, especially with regard of the influence of the Catholic Church? And a very concise question would be, do you know what exactly Dora Tagnieskova, who was burned at the stake, what was she accused of exactly? Thank you. And afterwards, one last question.
Okay, thank you for questions. So as for between 16th century and 18th century and Warsaw Confederation, so it was mainly for religions. So, and that's why Poland is called country without stakes, but not necessarily without stakes concerning witchcraft. So people weren't burned at stake because they were Protestant or Orthodox, or Catholic was a majority, of course, but all people, especially in the nobility, they have more or less equal rights, as of course we're talking here about men of nobility. So it's not like the Warsaw Confederation weren't in use de facto because we had witch trials. It was used. It was for I don't know, people who were Protestants could hold positions of power in state. Of course, the king must have been Catholic. So yeah, for the first question, that would be this, I guess. I mean, if you have any further questions to this first part, I will also answer. And for Dorota Gnieczkowa in Poznań, I believe she was accused by, I guess, some merchant from this town that she caused the damage in his farm by or in his, let's say, household, by causing some illnesses of animals. And some researchers even say, even in researchers in 19th century, that accusations concerning many different people, many different women, were actually very similar, just the names were changed. For example, as Gnieczkowa, that her neighbor's, I don't know, cow or hens died or something, and another would be very similar, or causing an illness, and so on and so on. Yeah.
Thank you, Katarzyna. And the last question from the audience, please.
Thank you for the lecture. After hearing so much about superstition in the Middle Age, I think that the audience will find it interesting that Serbian 2016 law on public order in Article 15 sanctions, I quote, casting spells, foreseeing the future, interpreting the dreams or similar scams done in such way that it disturbs citizens or harms public order by fine between 10,000 dinars or 50,000 dinars. That's approximately about between 100 and 500 euros.
The session, sorry, thank you for the remark, but this will conclude the session and invite you all who are present here for the lunch. Thank you.